friends, Namaskaram. How are you? Myself is Dr. Jinesh Soni. In today's class, we will discuss an important case regarding cheating and forgery. Basically, I will discuss an important judgment of Honorable Rajasthan High Court that is quite recent and judgment is pronounced on 7th of Feb 2026. In that case, a complaint has been submitted regarding the cheating and forgery. So basically, whenever we fight a case for cheating and forgery, as we know that we have to understand the psychology of the concerned complainant. So complainant will always submit that he has been cheated, and apart from that the police will lodge the FIR. Even they may pressurize you to do confess, and apart from that they may compel you to part with the money. So basically the concerned police will use the law as a tool, and they will emphasize on the threat mechanism. And when the FIR has been registered and even you are called by the police at the concerned PS, there is apprehension in your mind regarding the pseudo arrest. So in that scenario there is no need to worry. First of all, we have to collect the copy of FIR from the concerned court, and even you may obtain the copy through online process. After that we are supposed to give the reply, and in the reply we have to submit that why the case is false, means why the allegations are false and concocted. And apart from that we have to make a proper cash flow statement. And in case there is a forgery, so we may make a request as per the protocol of section 349 of the BNSS, so that entire position could be on record. And if the police is not willing to investigate on our point and they are totally willing to arrest us without any basis, then we could have the benefit as per law. So we might move in that circumstances either for anticipatory bail or for the questioning proceeding as per the protocol of section 528 of BNSS. You got the point now? So basically I will discuss one of the most important problem concerning the cheating and forgery. So basically, please be noted the legal point. Whether a magistrate can direct the police to do further investigation on the specific points. If the answer is in affirmative, then what we should do, and if the answer is negative, and in case the magistrate inter alia pass the order, then what we can do. So both the scenario will be discussed by us in the present episode. So in the present case at hand, there was a FIR for cheating and forgery, and ultimately FR was given by the police on ground that the key witness has not supported the case, and apart from that there is no corroboration. Finally, the concerned CGM has ordered for the FSL. He specified that the specimen is to be taken, it is to be sent to the concerned FSL so that the results could be obtained and accused could be prosecuted. Finally, the accused has filed the revision petition, but it has been dismissed. And finally, he has approached before Honorable High Court as per section 528 of BNSS. So he specified that the magistrate either accept or reject the final report, but he could not direct in which manner the evidence is to be collected. So if it is done in that scenario, it is overstepping of jurisdiction. Such directions are totally impermissible. So looking to the facts and circumstances, Honorable High Court has intervened and set aside the order of magistrate up to the extent of intervention, means the specification in which manner the evidence is to be gathered or collected. As we know that investigation is the prime function of police. So whenever the police collect the evidence, in case the concerned complainant is not satisfied, he may file the protest. But while making the order for the further investigation, the court could not specify what is required to be done by the concerned police. So basically, the collection of evidence is concerned with police, not with the magistrate. So basically, if you are going to fight a case for cheating and forgery, please remember and mark 5 important points. Number 1, as far as the offences of cheating is concerned, we have to emphasize that we inter alia have to show to the concerned police that there is no intention on our part to embezzle the amount or to misappropriate the amount. Rather than it is a civil dispute, but concerned complainant has inter alia converted the same into a criminal case. So basically, we have to specify that it is basically a civil dispute. For this, we may rely on the concept of cash flow statement. So it is basically the concept of accounting. For example, you have taken any money from the complainant, and complainant will say to the police that he has embezzled the amount. So simply we could show that we have taken the amount on credit, and inter alia we have invested the amount in various pockets. Ultimately, the concerned pockets wherein the amount has been invested, inter alia fail to refund the amount. So when they fail to refund the amount, I have initiated the civil proceeding. So in that scenario, there is basically a civil breach of contract, a civil dispute. So whenever we are having a civil dispute on record with the help of cash flow statement, in that scenario, the case of cheating would not lie. And apart from that, as far as forgery is concerned, the prime element must be on record that you have signed, sealed, or executed document with intention to support a claim or to cause damage to anyone and to cause wrongful loss to the concerned complainant. If such verbatim are not on the record, and apart from that, there is no specification to sustain the same, in that scenario, we could be on the best point. So basically, if the concerned complainant says that you have done the forgery and you are damn sure that you have not done the forgery, in that scenario, you may rely on the protocol of section 349 of the BNSS. In addition to this, please mark my words, In case FR is given and magistrate has made the order for further investigation, and in the further investigation order he specified the points to be investigated by the concerned police, means the way to collect the evidence. In that scenario, the order is illegal. We could challenge the order, and apart from that, the order is revisable. We could file a petition of revision before Court of Session as per the protocol of Section 442 of BNSS. And in case the revision court failed to intervene, we may file the further petition before Honorable High Court by the virtue of Section 528 of BNSS. So I specify you the various mode to intervene and various mode to specify your rights, so that you could protect your rights from being prejudiced, from being compromised. See you in the next video. Till then, Jai Hind, Jai Bharat.